Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about prison reclassification. Cases that should have gone to the Supreme Court of Canada, but didn't. Clifford Haldol was a prisoner in a federal institution in Canada. As a result of an incident that occurred at the institution, his security classification was reclassified from a minimum security to a medium security. And as a result of that, certain restrictions were put on him and he was transferred. Mr. Haldol was concerned about the reclassification and brought an application to try and demonstrate that the reclassification was unreasonable. That application was dismissed, he appealed, his appeal was dismissed, and he sought leave to the Supreme Court of Canada. The issues Mr. Haldol raised are very important. While decisions made by prisons to classify somebody as a medium or a minimum or a maximum security risk are obviously important to the functioning of the institution and are decisions that could be judicially reviewed, at the same time, the ability of individuals to bring challenges to the decisions made by the prisons is limited by the fact that they are in the prison. Documents that Mr. Haldol tried to obtain were unavailable to him as a result of the processes through which he could challenge this, and as a result he felt like he was unable to demonstrate that the reclassification of his status was something that he shouldn't have had done to him, and that there was some level of interference in the decision-making process. Unfortunately, because of the processes that prisoners have to follow to challenge these decisions, he was really at a loss to be able to make out his case, and this was the crux of the appeal. The Supreme Court of Canada had an opportunity here to get involved in what is an evolving discussion in Canadian law about how prisoners are treated and how prison officials make decisions within the prisons, whether it has to do with imposing people into segregation, whether it has to do with prison lockdowns, or classifying people as minimum, maximum, or medium security offenders. Mr. Haldol was at the forefront of what is an ongoing discussion in the criminal justice system in Canada, and the Supreme Court of Canada had the opportunity to get ahead of this, rather than wait for other cases where massive class action lawsuits or massive constitutional challenges are being brought. It's unfortunate the Supreme Court of Canada didn't see this as an opportunity to find an efficient answer to a significant legal question, and instead ultimately left people in the prison system continuing to be at a loss for how to bring challenges in their cases, particularly with respect to their classification. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.